Hi, this is Jack Razmich with Razmich & Delamater. I'd like to talk with you today about the discovery process in a criminal case. Before I get to that though, I do want to remind you that if you have any questions about this video or any other topics of law that we haven't covered yet, click the link at the below. That'll take you to a page where you can schedule a free case evaluation. Case evaluations are free and we're more than happy to speak with you. So what is the discovery process in a criminal case? Well, unlike what you see on television, you can't actually have surprise witnesses or surprise documents when a case goes to trial. Both sides, the prosecution and the defense, are required to exchange any information that they have in their possession they think has a bearing on the case. This is referred to commonly as the discovery process. Most jurisdictions in Indiana have what's known as automatic discovery, which means that your attorney doesn't need to contact the court in advance and specifically request things. There are a few counties though that do require the attorney to make a formal request, so make sure that you tell your attorney everything you know about your case, including where it's filed, so that he can advise you properly. The prosecution always goes first with the exchange, and their initial discovery disclosure requires them to turn over a copy of your criminal history, the charges they filed against you, the probable cause affidavit that was used to support those charges, and any police reports that happen to be in their possession that would have an impact on what did or didn't happen in your case. Now, there's usually more information that does get exchanged as the case proceeds forward, but that's the initial discovery that the prosecution has to turn over to you. Most jurisdictions, they have 30 days from the date that your attorney files his appearance form to turn that over to you. That's another reason to have an attorney on the case as quickly as possible, so that your case can start moving forward as quickly as it can. Your attorney, by comparison, once he receives the state's disclosure, has 30 days to turn any similar information back over to the prosecution with regards to information about witnesses that the defense might rely on, special defenses like self-defense or an alibi that they might be relying on, and things of that nature. The discovery process continues throughout the case, so you don't have to worry about asking every single time there's new information. For example, if there's a dash cam or a body cam in your case, once that makes it to the prosecution, they'll turn that over without your attorney having to worry about it. There are some things that attorneys don't have on either side. Medical records can be an example, training records for the police officers. Under those circumstances, your attorney can file what's known as a subpoena to the agency that has that information, directing them to turn that information over to you. Finally, the last thing that you can usually see in the discovery process are depositions. Depositions are kind of like mini hearings. What happens with that is you have a witness that you want to question. They're placed under oath and told to tell the truth, the whole truth, nothing but the truth, just as if it was in an actual courtroom. And your attorney's allowed to ask questions about that, about the case, about their background, about how they know the defendant, and they have to answer them. It's just like if you were in live court, except that there's no judge. Now, the discovery process is not a quick one. Most things in the law provide 30-day windows of opportunity for people to respond. When you send a subpoena to a hospital, for example, asking for medical records on a witness, they have 30 days to respond to that. When you schedule a deposition, you have to coordinate that with the prosecution's calendar as well as the witness who's coming, and that takes about 2 to 3 weeks there too, especially if you're dealing with a police officer. We do try to move these cases as quickly as we possibly can, because the last thing that we want to have happen is for your case to sit there without any activity on it. That's a quick snapshot of the discovery process in criminal cases. Again, if you have any questions, remember to click the link at the bottom. That'll take you to a free consultation page. I look forward to speaking with you.